Okay, we're back in public session. Pre-legislative scrutiny of the Housing Regulation of Approved Housing Bodies Bill 2015. Our meeting has been convened to discuss pre-legislative scrutiny of the Housing Regulation of Approved Housing Bodies Bill 2015 and related matters. The heads of the bill and other documents are available on the committee website, and members of the public are welcome to make comments. Is that agreed? Okay, I would like to welcome the following witnesses to the meeting. From the Housing Division of the Department of the Environment, Community and Local Government, we have Damien Allen, Principal Housing Division, Sheila Power, Housing Division, and Andrew Harkin from the Housing Division. From Cooperative Housing Ireland, we have Mr Kieran Brennan, Chief Executive, and Mr Dermot Sellers. From the Irish Council of Social Housing, for Social Housing, we have Mr Donald McManus, Chief Executive Officer, Karen Murphy, Director of Policy, and Justin O'Brien, President. I'm just going to read out the warning for all of our witnesses. It's a bit technical, so bear with me for about a minute or so. I wish to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are thereafter only entitled to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person, persons or entity by name or in such a way as to make him or her or it identifiable. It is proposed that the opening statements and any other documentation that witnesses have provided to the committee may be published on the committee website after this meeting. Is that agreed? Okay, Jim, I have the three opening statements. I would ask those who are speaking on behalf of the groups to keep your opening statements to about 5 minutes. The general gist of what you're saying is well documented. I am now going to call on Mr Damien Allen to make his opening statement to the meeting.
Thank you, Chairman and committee members, and thanks for the opportunity to discuss with you today the proposed regulation of Approved Housing Bodies Bill. Before outlining the main provisions of the bill, I'll just provide some brief background and context to the proposed legislation. Approved housing bodies are not-for-profit housing organisations formed for the purpose of relieving housing need and the provision and management of housing. AHBs consist mainly of voluntary or cooperative organisations registered under the Companies Acts, societies registered under the Industrial and Provident Societies Acts, and/or trusts incorporated under the Charities Acts. There are currently 536 approved housing bodies. At present, the sector is largely reliant on a mix of fragmented regulation under various legal instruments, including the Companies Act, the Charities Act, and the Industrial and Provident Societies Acts. The sector has grown over the past 20 years, but largely in a low-risk environment where the state has provided most of the funding to a level of 100%, 95%, 100% high-level capital funding. More recently, the sector has had to rely much less on such grants, much less so on such grants, and much more so on current funding, by which I mean borrowing to develop social housing. Approved housing bodies have a key role in the delivery of social housing as recognised and set out in the Social Housing Strategy 2020. And in this context, the need for regulation becomes more pressing in order to underpin stability in the sector, to better protect tenants and to provide reassurance to potential investors. At the moment, a system of voluntary regulation is in place. A voluntary code called Building for the Future was published in July 2013. And in February 2014, an interim regulation committee was established as an independent committee working within the Housing Agency, where there's a dedicated regulation office working as well. I think you heard from the regulation office last week. The committee includes experts on housing, finance, regulation and law. Encouragingly, the number of AHBs that have now signed up to the voluntary code, about 210 at the last count, represent approximately 82% of all housing stock held by AHBs. All AHBs signing up to the code are expected to submit a signed charter of commitments and to make themselves available for interview if necessary and for assessment. In July 2015, the Housing Agency published the Financial Standard and Assessment Framework, which was a further development of the voluntary code, as well as its first annual report. In the programme for government, a commitment was made to facilitate larger housing associations to access private sector funding for social housing. More recently, Construction 2020 and the social housing strategy that I referred to earlier affirmed the central role in which approved housing bodies have been placed for the provision of social housing. And the strategy includes a specific commitment to establish a statutory-based regulator for the sector, first signalled in the Voluntary Code. The interest of the tenant is very much to the fore in the development of Regulation 2. This is explicit in the regulator's oversight role of the performance of AHBs as regards their landlord functions, but it is also implicit in the regulator's focus on financial viability and good governance of AHBs, because these underpin stability and security for all parties concerned. And so it's against that background that in September of this year the Government approved the general scheme of the bill. The purpose of the proposed legislation is to safeguard public and private investment in AHBs and the assets developed through that investment, to provide necessary legal arrangements for the oversight of AHBs in respect of their governance, their financial viability and their performance in their role as landlords, to protect the interests of tenants and other stakeholders through the regulation of the AHBs in their provision of housing-related services, and to give assurance to investors that the AHB sector is well governed in Ireland. The main provisions of the bill are as follows. I'll just conclude on this, an overview of the main provisions. The creation of an independent regulator. The regulator will be responsible for establishing and maintaining a register of AHBs and for granting or refusing approval to applicant bodies for approved status. The regulator will also be setting and monitoring and assessing on standards. So the regulator will set standards and publish those standards and then assess the AHBs against those standards in relation to their performance generally. And the bill provides for a suite of enabling powers that will allow the regulator to make inquiries from AHBs and to make investigations if necessary, issue guidance and to make assessments regarding the performance of the approved housing body. The bill also gives certain intervention powers which will allow the regulator to intervene in many different ways according to the risk identified. Finally, the bill also provides for AHBs to adhere to certain obligations under the regulatory framework, including, for example, the submission of information to the regulator, notification of the regulator of any change in articles of association or memorandum, for example. The bill is a complex piece of legislation and it includes many provisions that will require careful legal scrutiny in the course of drafting. As the drafting of the bill proceeds, I expect that the proposals will be refined and the Minister will, of course, also consider any views of the committee arising out of the consideration of the bill. Thank you, Chairman.
And I will have the upper from Mr. Donald McManus.
Thank you, Chairman. Thanks to the committee for invitation to address you today. I'll not go through all the details of our presentation. You have some of the details in that, but just to pick out a few points. The Irish Council for Social Housing is a representative federation of housing associations or approved housing bodies, as they're called. We have almost 280 members who collectively provide over 30,000 homes for families, older people, formerly homeless people and people with disabilities. And at our peak, the sector would have taken 3,500 people off the waiting list in 2009, just to give you some scale. As well as providing social rented housing, a number of housing associations and approved housing bodies undertake a wide range of additional service such as community-based education, social and health-related supports. Housing associations range from a large number of organisations who provide housing and related supports and were established as approved housing bodies by local communities, often primarily catering for specialist groups such as older people, the homeless and people with disabilities, to a small number of larger associations providing housing over a number of locations and managing a significant amount of homes. Housing associations have delivered through new build provision, acquisitions, Part 5 delivery, regeneration projects with local authorities, as well as more recently various forms of leasing with the private sector, and importantly non-exchequer finance, which has been a big part in recent years. In terms of the structure of our associations, The majority are housing association incorporated companies limited by guarantee. They are governed by a board of directors, and where housing associations have sufficient scale, they employ specialist staff to undertake the operation of housing associations. A large number of small locally based pre-housing bodies have no staff, and their work is undertaken on a voluntary basis at no cost to the state. Overall, housing associations are motivated by providing good quality, well-managed housing at affordable rental levels. A small number of housing associations are also currently examining additional types of housing, such as cost rental and affordable rental, as part of mixed tenure developments. Currently, due to the range of activities approved bodies undertake, bodies often have to comply with a range of regulatory requirements, as we've mentioned, from a number of different bodies. This includes provision of audit accounts and returns to the Companies Registration Office, returns to the Revenue Commissioners and HSE were required, as well as compliance with the terms and conditions of capital funding schemes with the Department and local authorities. More recently, pre-housing bodies will have to comply with the Charities Act and the newly amended Residential Tenancies Act, where housing associations have to register their tenancies under the RTB. At the moment, there is no single body that has full oversight of the sector. The introduction for approved housing bodies of a regulator will provide an important level of assurance and confidence for the various stakeholders the sector engages with, such as financial bodies, elected members, local authorities, tenants and the general public. The legislation is focused on the organisational regulation aspects of approved bodies, not the landlord-tenant relationship, which will come under the Residential Tenancies Act and which approved bodies now have to comply with from 2016. Therefore, members of the committee can see the range of increased existing regulatory requirements that the sector has to comply with. In turn, it is important for a new statutory regulator to be fully aware of the regulatory requirements from all other regulators who have a role in the sector. In this context, we feel there is a need for a memorandum of understanding to ensure that the housing regulator is fully cognizant of the requirements of other regulators and should be provided in the bill. We believe the regulator should be independent to ensure credibility and ensure the regulator is not captured by any specific public or private interest. It should be in the public interest, whilst also have a key enabling role to ensure long-term sustainability of the sector. The regulator should set standards on finance, tenant services and housing management, as well as governance, and provide oversight with a plan of engagement and intervention where required. The regulator should not undertake a role that could be viewed as a shadow director or even micromanage the business activities of approved housing bodies. In part, we will see the regulator having to provide consent to an HB for disposal of an asset at the value of $10,000 is overly punitive, unless it was focused purely on assets, physical assets like stock. This could require, for example, the sale of a maintenance van, a photocopier from the regulator. In conclusion, I'll summarise some of the points in response to questions posed by the committee. I will be making full submission on the heads of the bill to the committee. We welcome the introduction of statutory regulation as an enabling and supportive role for the sector, and believe that as the heads are currently worded, the spirit isn't fully captured as yet. My key object is the insurances to be provided to tenants, and there's detail to be worked out on that as yet. The principle of proportionality needs to be maintained to ensure that smaller, locally voluntary food housing bodies are supported during the transition to statutory regulation rather than undermined. The heads introduces 7 offences for non-compliance, which is harsh for many small HBs, and this needs to be handled proportionally and flexible in this transition. The powers of the regulator are extensive. However, there's a need to ensure greater clarity over how they will work, both on heads number 11 on consent for disposal, and number 12 on appoint a manager, board members, and 16 on their interim premises. For example, these are extensive and may be seen as intrusive by some bodies unless dealt with carefully. Detail on proposed coordination across many agencies is needed on how they will interact and whether the regulator will drive cooperation with regards to PRTB or Charities regulator. In conclusion, the ICCH welcome continued engagement as a representative body for HBs in the development of this legislation and its future implementation. Thank you, Chair.
Thank you, Mr McManus. Now we'll have the opening statement from Mr Kieran Brennan from the Irish Council from the Cooperative Housing Ireland.
Thanks, Chairman. On behalf of Corporate Housing Ireland, I would like to begin by thanking yourself and indeed the committee for inviting us to participate in consideration of the statutory regulation of approved housing bodies, AHBs. Cooperative Housing Ireland was formed as NABCO in 1973 to represent, promote and develop the cooperative housing movement in Ireland. We work with local housing cooperatives to help households meet their own housing needs in any tenure and have supported 3,500 families into home ownership through local building cooperatives. The Society is also an AHB in its own right and today manages more than 1,800 social rented homes through a network of affiliated local cooperatives across Ireland. The organisation is fully committed to playing its part in delivering objectives in the social housing strategy and has plans to deliver a further 1,500 homes over the years to 2020. Cooperative social rented housing is distinctive as tenants are also shareholding owner members of their own society. Members elect the management committees of their local societies and in turn select representatives to the national board of the organisation. Cooperative Housing Ireland has a board with the majority tenant representation on it, supplemented by external expertise in governance and housing. Housing cooperatives are typically formed as industrial and provident societies and are registered with the Registrar of Friendly Societies. They apply for AHB and charitable status in the same way as other housing bodies. Cooperative Housing Ireland signed up to the Voluntary Regulation Code published in autumn 2013. The Society has participated in 2 years of regulatory assessments. In addition, in the current year, the Society has participated in further voluntary oversight of its financial performance. The experience of the Voluntary Regulation Code has been a positive one, with the Interim Regulation Office engaging on a proportionate basis and with a view to enabling compliance with the terms of the Code. It is our view that the spirit of enabling and facilitation should be brought forward into the emerging statutory framework. Cooperative Housing Ireland welcomes the move to statutory regulation of the AHB sector. While the motivation for introducing this legislation may be to protect public investment or to promote further investment by the private sector, it is the view of the cooperative housing movement that the primary aim of regulation must be providing assurance to tenants of AHBs that their homes are secure now and into the future. We recognise that the suite of powers developed for the regulator has been drafted with a view for the worst case scenario, requiring legal enforcement and even the transfer of an AHB's housing commitments. Nonetheless, we remain convinced that the main approach of the regulator should be towards enabling the sector to play a fuller part in delivering social housing and in recognising the diversity of approaches that the sector can bring to bear. To be effective, the regulator must be independent and must be seen to be independent. While the context of the current legislation is to facilitate private sector investment by way of meeting the ambitions of the social housing strategy, the regulator must have an eye to long-term sustainability. For this reason, we advocate establishing the regulator on an entirely independent footing and creating a clear distinction between the regulator and the housing agency. Equally, we advocate that positions on the board of the regulator be advertised publicly and that provision be made for appropriate tenant representation on that board. This enabling approach that we recommend to the regulator adopting will be critical in the period during which the Act comes into force and in the early period of its operation. We recommend that consideration be given to a process by which AHBs which do not hold stock or do not intend to develop stock can notify the regulator before they find themselves subject to the full set of regulatory requirements. Equally, it is key, especially for smaller and voluntary AHBs, that the regulator is given sufficient flexibility to engage informally around compliance before the statutory powers are invoked. We welcome the bill contains such clear recognition of the roles of the industrial and provident societies and also many mentions of the Registrar of Friendly Societies. And we would ask that it also mention under Head 11, Subhead 3A, rules as well as a Memorandum of Association. The explanatory notes of the bill suggest that it is not expected that AHBs contribute to the running costs of the regulator. We would suggest, therefore, that this provision be removed from the bill, requiring that any change of policy in this area in the future requires new legislation. Equally, the proposal in the current bill that AHBs contribute to a fund to be used in the event of a transfer of AHB assets in future should also require further legislation. AHBs already pay local property tax for their stock, as well as contributions to the PRTB. Further requirements to fund the operation of the regulator would add another unwarranted financial burden that would hamper the ability of AHBs to meet pressing housing needs. Heads 13 and 17 relate to the issue of further standards and guidance. Due consideration should be given to the proportionate impact of these on the sector. We recommend that a regulatory impact analysis be carried out on these standards and that it is a requirement that consultation is undertaken with the sector. In our response to the committee's questions, we raised concerns about the proposed restrictions on the disposal of assets. The limitations suggested do not appear to be proportionate or appropriate, and we would question whether they will assist in promoting confidence in the sector among private lending institutions. We also note concerns around the proposed process for the transfer of housing between AHBs. The acceptance of new housing by the recipient AHB is not necessarily merely gaining an asset. There are potential liabilities attached to any property. Due consideration should be given to the supports that may be required, including the provision of state funding other than lending from AHB funds as described in the bill. In conclusion, we would like to thank the committee again for their engagement around this vital issue. Cooperative Housing Ireland will make a full submission to the bill by the 21st of December, and we have already prepared and submitted answers to the detailed questions proposed by the committee. Thank you.
Thank you. Thank you very much indeed for that, Mr. Brennan. Okay, now we'll go to members. Now we'll go to members' questions, and we can direct those questions obviously towards our visitors. Just make the questions as concise as possible so it will allow a very orderly exchange of information between our visitors and our questioners. Deputy Catherine Murphy.
Right, thank you. I'll go in the order that the contributions were made, and thanks for coming in. Obviously, we're looking at every available option in terms of upscaling and having a more diverse housing stock, and obviously the approved housing bodies are very much part of that. The voluntary code, generally, I'd be curious as to how people felt it worked, because obviously it's a precursor to this. If there are things in it that didn't work, that are, that we have a danger of repeating. In terms of upscaling, is what's proposed going to assist in upscaling? Because one of the things that was very obvious when we had the housing agency in before was they told us there was a lot of money available that could have been accessed from the like of the European Investment Bank or possibly pension funds or whatever. But in actual fact, when you talk to the housing associations themselves, they tell us just how difficult that is. And it's quite useful for us to understand that, and also understand what might be done to improve. What they were talking about, or some of the housing associations were talking about, some level of co-responsibility or some co-guarantee with the approved housing bodies. Do you have any kind of assessment of what might be possible in the next 10 years?